order for May the 12th, 2026. Please stand for invocation and pledge.
Dear Heavenly Father, we thank you for this day, Lord. Thank you for bringing us all here together. Please guide us and direct us as we make the best decisions for our community. In Jesus' name we pray, amen.
Amen. I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning and welcome. Under the consent agenda, tab 1, we have the bills for the city of Freeport. Tab 2 is the regular council meeting minutes for April 23rd, 2026. And under tab 3 is the water and wastewater capacity fees. Is there any public comment on the consent agenda? If not, I'll ask for approval from the council.
Make the motion to approve.
Second.
Motion's been made and seconded. Councilwoman Hafner.
Aye.
Councilwoman Hirsch.
Aye.
Councilman Ferris.
Aye.
Councilwoman Brandon. And Councilman Dickey.
Aye.
Motion carried. Are there any additions or deletions to today's agenda?
Under engineering, I'd like to add a change order number 1 for the 2 MTD wastewater treatment facility.
Any others? If not, I'll ask for a motion to approve.
I'll make a motion to approve.
Second.
Motion been made and seconded. Councilwoman Hafner.
Aye.
Councilwoman Hirsch.
Aye.
Councilman Ferris.
Aye.
Councilwoman Brandon.
Aye.
And Councilman Dickey.
Aye.
Motion approved. City manager.
Good morning, council and mayor. First topic I have is just for discussion for the fee waiver process for June. This is the first time we're doing it, so everybody for 2027 has to get their information in June of 2026. Rebecca emailed y'all the existing not-for-profit fee exemption policy, along with the application or the request for fee waivers, and then lastly, an existing Excel spreadsheet that we found. So, I just want to make sure I'm getting it right for what y'all want. Rebecca was nice enough to make some adjustments. You should have in front of you the not-for-profit fee waiver exemption policy that we've made some changes to. And tried to sort it out a little differently as parks, facility, the only facility, which is the Blunt House, and then the statement on the community center. So, my first question is, does council want people to come and make the presentations, or do you want Rebecca and I and Red or whoever to gather all the information, put them on a spreadsheet, bring them to you at the second meeting?
Yeah.
Councilwoman Brandon.
Thank you, Mayor. I would prefer you to do what you just said, get a spreadsheet together. I know that when we had this policy before, we didn't have a U. So now that we have a U and a lot of other staff, I would think y'all could get that at staff level and get it to us.
All right.
I have a question, Mayor.
Councilwoman Hafner.
Thank you. On the community center, the blurb underneath, I don't know that I want to get involved in a workshop to discuss fee waivers, and we've already said there are no fee waivers other than city events and other government entities. To me, that's a bit of a slippery slope if we start going back on the policy we've already voted on. So to me, it's a pretty hard, we've already
agree.
voted on that, so
We'll take that out.
that's just my opinion.
I agree.
Okay.
Clay, do we need motions and all that, or is just direction good enough?
I mean, since you're gonna be, I'd like a motion to establish the policy that the council will have staff compile this information and present it to you in spreadsheet.
So moved.
Second.
Motion been made and seconded. Any further discussion?
Oh, it was on.
Councilwoman Hafner.
Aye.
Councilwoman Hirsch.
Aye.
Councilman Ferris.
Aye.
Councilwoman Brennan. And Councilman Dickey.
Aye.
Motion carried.
second item is procurement of a 36-month agreement, which is why I'm asking for a motion to approve the agreement. It's for an iPad for the pool so that we can set up a POS system and kind of transition from just having a cash register to having an actual
Yeah.
POS.
Yeah. Okay.
Hopefully will help accounting and all that. Just
Okay.
looking for a motion to approve.
I'll make a
It's
motion.
$20 a month.
Yep.
I'll make a motion to approve.
I'll second.
Motion's been made and seconded. Any further discussion?
And Clay has looked at it.
I am good.
Any public comment? Councilwoman Hafner.
Aye.
Councilwoman Hirsch.
Aye.
Councilman Ferris.
Aye.
Councilwoman Brennan.
Aye.
And Councilman Dickey.
Aye.
Motion carried.
That's all I have. Thank y'all.
Engineering.
Morning, Council, Mayor.
Good morning.
I'll start with the addition as the first item. So, as you all know, the city's 2MGD treatment facility is being funded by a loan grant agreement through USDA. With the way the bids came in, there is additional grant funding that we'd like to see about having the city spend. So, we had some discussions with Paul about some improvements that we'd like to see at the treatment plant. One of them is additional concrete pads to cover the dewatering. Right now, where all basically the dewatering bins go, there's not enough space. So what this change order would propose would be additional concrete slabs in that area. What would happen is this amount would be completely funded by the grant through USDA. So if the city approves this change order, we would then take this change order, submit it to USDA for their review and approval. They may allow us to do it, they may not, but if they do, it would be 100% grant, so no money that's coming out of the city's pockets. So with that, I'd be looking for a motion to approve this change order so we can submit it to USDA for their review and approval.
And Bruce, you've
I'll make the motion to approve the change order.
I'll second.
Motion's been made and seconded. Is there any further discussion? Is there any public comment? Councilwoman Hafner.
Aye.
Councilwoman Hirsch.
Aye.
Councilman Ferris.
Aye.
Councilwoman Brennan.
Aye.
And Councilman Dickey.
Aye.
Motion carried.
All right, the second item we'll do is the Bay Area Sewer Expansion Phase 1 change order for additional vacuum sewer materials. So for this project, the city is purchasing the vacuum sewer materials that are coming from Airvac, the vacuum sewer supplier. They're doing that in order to not have to pay the additional sales tax to save some money. So we've been installing the valve pits for this project area, but we need an additional 25 valve pits. These pits can serve up to 4 properties, but some of the properties, just the way their septic systems are, have required, more than basically, individual connections or so forth. So we're looking for an additional purchase of 25 valve pits and the associated equipment. The total cost would be $150,402.50, and this would be materials purchased directly by the city from Airvac.
And that budget is also covered within the grant funds, so those funds in the budget.
I'll make the motion to approve.
I'll second it.
A motion's been made and seconded. Any further discussion? Is there any public comment? Councilwoman Hafner.
Aye.
Councilwoman Hirsch.
Aye.
Councilman Ferris.
Aye.
Councilwoman Brennan.
Aye.
Councilman Dickey.
Aye.
Motion carried.
All right, and the third item is hold on, I have the wrong title on this, but is the Business 331 sidewalk extension. I apologize, in the agenda, title's correct on the agenda, but just in the agenda summary, it's incorrect. So we have the 100% design completed for the Business 331 sidewalk. The cost opinion for that project is around $1.2 million. There was additional stormwater drainage improvements that had to be done because of the limited right-of-way. That increased the cost by about $300,000. I anticipate bids will come in somewhere between $1 million to $1.5 million. So we just wanted to kind of discuss this item with y'all because I know this substantially more than the original budgeted amount. But this would cover sidewalks going from State Road 20 to Kylie Laird tying into where the Safe Route to School project ended their sidewalks. So,
Mr. Mayor, I have a question.
Yes, sir.
So, question is really for Clay. Because this is substantially higher, can the council just approve for Dewberry to put this out to bid and that's it, or approve the engineering fees and the ability to put it out to bid? So we're not necessarily, I just don't think the council should approve
yeah.
the 1 point whatever. Let's put it out for bid and then he can bring it back.
Yeah.
Right now, yeah, that's,
So what you've got to first decide is, are you gonna approve the engineering fees associated with this? That's the first step. After you make that decision, because you voted no on that, it might not be in the bid. After that, then you're in a position where you have to put this out for bid. So if the request is just the approval of the fee submittal he's making, that's motion one. Motion two would be the public procurement being authorized to be issued.
and I'll just add to that. So right now, we have the bidding covered in our current fees. So what I'd like to do is basically make sure you guys are okay with the scope of this, and then give us permission to put it out for bid. We'll put it out for bid, and then once we get the bids, at that point, we would give you a proposal for the construction services, and then you all would see what the actual
So
construction
we could do
cost
that
would
as
be.
one motion to approve the scope and authorize the issuance of the bid documents.
We can still refuse the bids if they are
It's
outside.
If you move standard language, city reserve right, we're getting all bids and moving town for all bids.
Yeah, correct.
Move on.
Councilwoman Hefner.
I see the note on here about acquiring an easement from Destiny Worship Center.
Correct,
So
yes.
where are we at? in
Yeah,
that
so that's
process?
in with the city's attorney. We've already had
Okay.
multiple discussions with Destiny, so it should be good. It's just a matter of finalizing the paperwork.
Oh, okay.
They've really worked good with us.
It just said
Oh,
pending,
yes.
so I would just need,
Yeah, I don't see
right,
that
just
being an
checking.
issue. Once this is issued, we will get that back.
Thank you.
Well, I'll make the motion to approve the scope.
I'll second.
Motion been made and seconded. Any further discussion? Is there any public comment? Councilwoman Hefner.
Aye.
Councilwoman Hurst.
Aye.
Councilman Ferris.
Aye.
Councilwoman Brandon.
Aye.
And Councilman Dickey.
Aye.
Motion carried.
All right. Thank you, council and mayor.
Thank you.
Thank you.
Thanks, Alex.
Finance.
Good morning, Council, Mayor.
Morning.
The item here is under tab 8. It's on an adjustment for the property insurance. Basically, we do this once a year in May, and as you may recall, when we did the budget, the increase had come through. What they do is a look-back audit of the prior year. So when the treatment plant, the original $30 million treatment plant, was put in service in April of '25, that did not get taken into account during the '25 fees. So this is an adjustment for that period, and so their billing is now for the $75,407. The sewer plant has been in since it went into service. They underwrote that, and it did get picked up as coverage, but this is a look-back adjustment for the period of time that it came in. So what I'm asking for is council motion and approval of this budget amendment and the expenditure so that we can pay the bill to FMIT.
All right, I'll make
Again.
that motion to approve.
I'll second.
Motion's been made and seconded. Is there any further discussion? Is there any
Just so
public?
council knows, Bruce and Chris worked very diligently to get FMIT an updated asset list. So that's something that hadn't been done in a while. And that includes, lift stations, you name it, cars, trucks, buildings, all that good stuff.
Thank you for that.
Oh, yeah,
Yeah,
sure.
thank you. Appreciate it.
Is there any public comment? Councilwoman Hefner.
Aye.
Councilwoman Hurst.
Aye.
Councilman Ferris.
Aye.
Councilwoman Brennan. And Councilman Dickey.
Aye.
Motion carried.
All right, thank you.
Thank you, Bruce.
Thank you.
Parks.
Good morning, council, mayor.
Morning.
So I have two items. The first one is looking for approval for the USSSA baseball, looking to come to our sports complex on May 30 and 31st. Pretty much, and it's an all-day thing. They did the same thing last summer, so it was a pretty good turnout.
I'll make a motion to approve.
Second.
Motion been made and seconded. Any discussion?
Are they asking for a fee waiver, or you're
No,
just
no.
asking to do the tournament?
Just to
Okay,
do
I
the
was just
tournament,
double-
yeah,
I
no
was
fee
just
waiver.
checking. Thank you.
Okay, any public comment? Councilwoman Halfron?
Aye.
Councilwoman Hirsch?
Aye.
Councilman Ferris?
Aye.
Councilwoman Brennan?
Aye.
And Councilman Dick.
Aye.
Motion carried.
The second one is the fire cadet at the sports complex, the pickleball court. It's a fundraiser. They did the same thing last year. Looking for approval on that. He's here today to explain to you if you need to.
No, I'll make a motion to approve.
Okay.
I'll second
No
it.
worries.
Motion been made and seconded. Any discussion? Is there any public comment? Councilwoman Halfron?
Aye.
Councilwoman Hirsch?
Aye.
Councilman Ferris?
Aye.
Councilwoman Brennan?
Aye.
And Councilman Dickey.
Aye.
Motion carried.
Yep, thank you.
Thank you.
Thank you, Brad.
Planning?
Good morning, Mayor and Council.
Good morning.
So, at council direction, we conducted an RFQ for continuing engineering services. As you know, we currently have 3 engineers on our roster. We have Dewberry Engineering, we have All Day Howell Engineering, and we have Anchor CEI. And the object of this was to see if there were other engineers in the area that were interested in providing engineering services for us. We obviously, based on our infrastructure projects that you're made aware of every couple of weeks, we have lots and lots of projects to go around. And it was just to see who's in the area, who's local, who has the ability to provide those services to us. And we have the attached rankings. We had, the committee actually was myself, Mr. Mark Martin, the city manager, and Council President Eddie Ferris. So we opened all the packages at that time, and we reviewed each of them, and we used ranking criteria based on the RFQ to determine how closely they match the needs of the city, how local they are, known information about their ability to provide service or their understanding of the city's particular needs in terms of our infrastructure, and really the philosophy of the city in terms of how we grow and how we conduct business. So that was very important as well. And Ms. Rebecca McClendon, our city clerk, was there to take notes and do the actual ranking. Once the committee provided their scores, she put them all together, and you see before them the ranking of the projects. The number 1 is the highest ranking, and number 7 was the lowest ranking. And you can see it at the top spot was Now or Never Engineering with a score of 281. The second ranked engineering firm was North Florida Professional at 252. In third place was Environmental and Geotech Specialties, 248. In the fourth place was CPH at 244. And the fifth place was Innovis Consulting Group at 237. And sixth place was LIA Engineering at 235. And number 7 was Gordon Moeller Engineering at 219. All Day Howell did submit a package once they read it, because they weren't completely sure if everybody needed to resubmit or whatever, but we noted that they are an engineer in good standing, and we did not rank their project as they are already providing services for the city. So you have the ranking before you. I await your pleasure. How do you want to look at? I don't know how many you want to add in addition to what we ever have. Do you want to look at the top? Do you want to look at the top 3? I'm just throwing things out here. At this point, we've done the RFQ, we've presented the rankings, and now it's up to the council of how we proceed from this point.
least a couple, you know, 2 more to our list would be a good idea.
I'd be fine with that.
Okay.
Do we need a motion for that?
Yes, we do. So
I'll
we
make-
would need a motion to accept the rankings of staff and to authorize staff to negotiate with, and a couple means two, but why don't you give me a number, 2 or the top 2, top 3, or actually say this, if you're wanting to hire more than one, direct staff to begin negotiations with the firms with the intention of adding, you fill in the number of firms to our rotation.
Councilwoman Brandon?
How many do we already have in our rotation?
3.
We've already got 3? Okay. I'd be fine with 2 or 3.
So what do y'all want?
So-
Add 2, add 3.
I say let's go with 3.
What, 3 more?
3 more.
Okay.
So the motion to accept the ranking, presented by staff, and authorize staff to begin negotiations with the top-ranked firms to secure 3 additional continuing contract engineers on the rotation.
I'll make a motion as stated.
I'll second it.
Motion been made and seconded. Any further discussion? Is there any public comment? Councilwoman Hafner.
Aye.
Councilwoman Hurst.
Aye.
Councilman Ferris.
Aye.
Councilwoman Brandon.
Aye.
And Councilman Dickey.
Aye.
Motion carried.
And Latilda, based on the way the RFQ is issued, you will still go in order 1, 2, 3 through 7, but you will not negotiate with 2 or 3 at the same time, based on the way the RFQ is written.
Correct.
The RFQ gave the city, and the reason for that, just so you understand, council, is that it gave us the option to select 1 or more. So the way the law works on that point is if it says we're gonna select more than 1, or it says we're gonna select a set number, you can begin negotiation with the top 3 if it says you're gonna pick 3, because those necessarily could be your 1, 2, 3. It allows you to do it for expedited basis. But since you have to follow the negotiation rules consistent with the ranking, you can't go by number 1 until they pass. So since this was 1 or more, that's why we're gonna do it. So you start with number 1, if they accept, they're on the list, you go to number 2. If they don't accept, you go to number 3, they become number 2, but you never go back up the list.
Got it.
All right.
It will be done.
Thank you.
Thank you.
Thank
That's
you.
all planning has this morning.
Next, we move into new business. I would like to take my second item first, please. This is an email that was sent to me from David Nunes. He's the president of the Freeport Touchdown Club or whatever, and it has to do with an hour-long radio show that's simulcast on YouTube and Facebook Live. And it said it's going to highlight the Freeport schools, and it would highlight businesses in Freeport, and wanted to know if the city would be interested or could help in securing this. I just told him that I'd be glad to bring it to you and present it and go from there.
I have a comment, Mayor.
Councilwoman Hafner.
To me, if it's really gonna highlight, you know, the schools and local businesses, maybe he should talk to them about potentially sponsoring money. That, to me, that's just a large amount of money for us to spend on that. So I don't know that I'm not really for that.
Well, I don't think that we had budgeted money for that.
Right, that's what I'm
Yeah.
saying, I just don't,
Anyway, I did what I said I would do.
absolutely.
I brought it up, and I'll just tell them that it wasn't in the budget. Is that good?
I think
That's
so,
good.
yes,
Yes,
sir.
sir.
Thank you.
Thank you.
Next, we have the Employee of the Month. It's a pleasure for me today to present to you the Employee of the Month for April. And it is in recognition for dedication, passion, and hard work supporting the residents of the City of Freeport. The Employee of the Month is April Nickens with the Accounting Department.
He had to get you in here, April, you know.
Next is Councilman Ferris.
Thank you, Mayor. I wanted to bring up to the council, I had a meeting, or had met with Charlie Simmons, and we were talking about the car property, and talking about the future use of doing the sports complex. And one of the things that we discussed, and I wanted to bring it to the council to see how the council felt, but of joining or maybe setting down, having Latilda, I did talk with Latilda about this, and she can also help me, but having us to sit down with the school district, also with the county, and see if there's some way of coming up with maybe a joint thing of all three of us working together, of being able to build a sports complex out there that would benefit everybody. The school district, the way that they're looking at it is they will have an elementary school on one side. They're gonna have the future land for the middle school, and if they can come up with some of their ideas of using one end of the sports complex for their purposes, it would all be out there together. But I think it's something that if we will sit down and talk with the stakeholders and have, just like with Red, that involved with Latilda and whoever, but of being able to sit down with our county administrator, with the school district, see what we can come up with, see what ideas we can come up with something that we can put together and make this a great sports complex. And I'm gonna let Latilda explain a little bit about our conversation.
And Councilman Ferris is right on target. As previously approved by this council, Councilman Dickey and I had been working diligently to meet with the Carr property family and with the school district on the location of the two new schools, not one, but two new schools, an elementary school and the middle school. They are modifying the project so that the regional park that is planned is in close proximity to the schools. One school will be on one side of the park, and another school will be on a different side of the park. And in discussion, it has already been discussed, and I agree with Councilman Ferris that this is an opportunity to work with the county administrator, the director of public works, and continue to work with the school district to figure out if there's a way we can jointly partner to create this regional sports complex that's obviously going to serve the entire central community. There's no reason why that can't happen. The school district is always willing to work with us, and this is the right time to draw in the county to have them participate at this level to talk about it. I would even call in their director of parks as well. And of course, Red needs to be there because ultimately it's going to be Red and his department that's going to be in charge of maintenance to know what we should or should not do based on his experience. And I think this is an excellent time for us to come together and talk while it's still in the planning phases about how all the entities, the county, the city, and the school district can work together on this. We had a similar joint partnership when we were beginning the development of the Freeport Regional Sports Complex, because we went out for multiple FERDAC grants to get that done. At the time, Preble Ridge did the designs that were also reviewed by Hammock Bay, because one of the conditions of us having the property was to develop it so that it was compatible with the design of Hammock Bay, and that happened. And the county also, while we went and got the money, the county donated materials and manpower to help us with that. And we have a long-standing agreement with the school district and with Walton County about use of the park. And this is yet another opportunity for us to develop another stellar sports complex that can be recognized all over the community. In my younger days, I had boys playing ball. I think some of you have boys playing ball. And we had many, many, many tournaments with Little League, Dixie Youth, adult softball. All these different tournaments were coming. And never, to a man, every person who came to our park said, this is the most beautiful park in the state of Florida. We can't believe that you have this kind of facility up here. And we've always been so proud of it because we get so much positive feedback about the design of the park, the way the park functions, and how well we can do tournaments here. Well, frankly, we're busting out of the seams. We have a lot more children now, therefore we need a lot more ball fields, we need a lot more multi-purpose fields, but there's no reason why we can't design this park so that it's not only an amenity to the schools, it's also an amenity to the community. And portions of it can be open to the community at all times, but there are portions of it that can be set aside for the children during the school day, and we're working on that with our design. The folks at the Carr family are very happy to work with us to do these considerations. And as Councilman Ferris said, this is the perfect time to make those decisions before it actually gets started. I mean, then the changes they want to do not only benefits the school district in providing that property for 2 additionally much-needed schools, it also provides us an opportunity to have that dialogue with the county on what the overall needs are of central Walton County in terms of services for our children.
And the county right now is in the process of looking at redoing some of their facilities and doing what they can.
Yes.
But I think if we let Councilman Dickey, Latilda, Red, be able to sit down with them, be able to talk, come up with a plan, come back before the council. My thing is to see something for the kids of our community, because we are busting out of the seams. And that's for our Freeport Regional Sports Complex. To me, that is the apple of the eye of Freeport. And I am all about trying to do something for our kids. And with this here, it's not gonna happen overnight, but it's something too that we can get there. And one of the things that I'll throw out too is maybe in the process of talking, of looking whether or not we could build a rec center out there where you could have indoor basketball or whatever. Being able maybe to have property that if the Boys and Girls Club wanted to come in, if we were able to donate land and them come in and build something and them run it. To me, it gives our kids something as we continue to grow. And I just wanted to bring it up. I wanted to make sure that, or we need to do a motion to be able to have Councilman Dickey and Latilda and Red to continue and meet with the county and the school board and or school district and see what ideas we can come up with of working together.
I have one quick question. Since the council had previously approved a conceptual plan for that entire property, planning question, if they change that, they will need to bring a new conceptual plan.
That is correct. They're, at this point, they are massaging the plan, you know, as when they move into their ground truthing and doing all their environmental assessments, their wetland assessments. There are going to be some tweaks, but they were listening to the community and to the council when they got that plan approved. And they're trying to move the schools more interior to the project so that the bulk of the traffic is not going to be down at 3280. They're trying to move it so that there are multiple ways you can get to the school, at least 2, probably 3, and that hubbub of activity is not happening directly down on 3280, because that was a concern expressed by the community. The Carr family heard them. So they're saying, well, let's move it up this way, and let's do 2 school sites and not 1, and let's put the park between them and find a way to make that all coexist. So as a point of process, once these things are figured out, they will come back and say, okay, here's the massage conceptual plan, and what we think is based on all our conversations with the county and the city and the school district, this is the new location of these things, and this is how this changes the configuration of the road and those kinds of things. Yes, they will be bringing back an amended plan for that. But before they go to the trouble and expense of amending that plan, they want to make sure that the city's happy, the school district's happy, And if the county is a part of that, the county is happy with what's going on. So this is an opportunity to build some bridges and provide some close coordination on some issues that affect us all.
Councilwoman Hafner?
I think Mark needs to be involved in all these conversations, as this was really be under his purview, I think, as the city manager, so that he can tell the rest of us. I had no idea anybody was meeting with the Carr family. I didn't really think we were supposed to be meeting with developers, so I didn't know. I mean, it's fine. I just would like Mark to be involved so he can communicate to us. It all sounds great and exciting, and I'm happy to have it, but I just would like to know kind of what's going on, and we can know that through Mark, you know.
Certainly can make a motion, absolutely.
Well, I'll make the motion to have Mark, Latilda, Councilman Dickey, and Red involved in it, being able to sit down with the county, the school district, and see what we come up with.
And
of
the
working
developer,
together.
too.
Huh?
And the developer.
And the developer,
Yes,
a rep from them.
sure.
Should y'all consider a public meeting in case people from the public wanted to come, like a workshop or
With that
something
many-
maybe?
That many people involved in the
I
county and
mean,
the city.
I feel
would
like
think
it's a
it'd have to
lot.
be-
Yeah,
It's gonna have to be advertised well.
I would think, right?
When
I
they
would-
do the, when they go back through the PDP revision process, that will be noticed. There will be a public hearing in front of the Board of, Development Board, the Planning and Development
Okay.
Review Board,
Okay,
and property owners will be notified. And there'll be an ad in the paper, you know.
What I would recommend, because we don't know what that revision's gonna look like and may include other facts, that's not the same thing I think the council's asking.
no.
What I would recommend, though, is that if we're designating Councilman Dickey to take that role, I think that addresses your comment down there, Councilwoman Hafner, about who's meeting with which development team and otherwise. That way we have a dedicated rep from the council, along with Mr. Martin and Latilda, having that meeting with the developer and the county. Why don't we start with that? And the school district, of course. Once there is some idea of who the stakeholders that are gonna be involved in, is when a community meeting would most be appropriate. So when you look at what we did with the Hammock Bay Sports Complex and the regional sports complex out there when that
Right.
started, there were many, many, many meetings between the city and Mr. Odom and his team first, that then included the county, and then became part of the public process to talk about doing a sports complex, that then came to what Latilda's talking about, the actual Hammock Bay PDP approvals. And I advocate it that way for the very simple reason that we were able to well document when questions were later raised about that donation of land and how that went down and what was, what was bargained for there. We were able to show, no, this was a discussion about getting a regional sports complex. It started at this level because the city would have been the donative entity. We're the ones who would take title, perhaps. And then the county would be involved. And so we were able to show where it built linearly outside of the PDP process. Because that was one of the questions, was this some type of bargain for exchange that created a contract zoning implication? And no, it clearly was not. Certainly you look at their houses being built in Hammock Bay well prior to that, just so everybody's always aware, even though that's been said, that park was built when nothing was out there. That's not an accurate reflection. But I think it would be great if we could see, if the school district, for instance, does not want to be involved, inviting them to a community meeting is not going to help. And I'm not saying, I'm just picking them, I could have said the county. Obviously, Freeport wants to be involved based on the motion. So we need to see who's going to be involved, and then we put all the appropriate staff people together and host community meetings that would address this within the city about what we need. That's my recommendation, is start the conversation, bring it back, make sure the council's still good, and then let's get community meetings going to talk about what can and can't be done out there. Because certainly, when we talk about sports complexes, I think we all know we could probably build 8 more baseball fields right now and accommodate need. But we're also duplicating the need there. Is there something else we need over there? Do we need a different type of field? Does that need to be a complement to, or does it need to be an addition to? And so those are the different kind of conversations we need to have. And then ultimately, the other reason that I am suggesting, and I'll go ahead and say it while it's on the public record here, that we should start this with an internal conversation, is that if the developer has certain requests or requirements, and there were certainly with the regional sports complex at Hammock Bay, we need to know what those look like one-on-one. They may get told no straight out the gate because we legally might not be able to do them. But also, they may be something that runs counter to our commitments and obligations at the regional sports complex. So we need to address those because, in all fairness, there were things, and when I say, there are things we could not do, not because it was an unlawful ask in the sense of criminally illegal or something, but there were simply things we as a municipal government could not do relative to a public-private partnership on property that may have been owned by the city but fully managed by an HOA, things of that nature. At the time that was presented, the rep from the developer in Hammock Bay wasn't aware of that, the original representative, who was Mr. Odom's employee. So we had to explain some of those things. That's an educational aspect that we give to people we're talking about public-private partnerships with. I don't know what Mr. Carr thinks or what Mr. Simmons is gonna think on his behalf, but if they propose something, we just have to say no. It's usually not gonna be no, we just don't wanna do it. It's no, we can't do it that way. Let's talk about the right way to get it. So before we throw an idea out there and the public says, well, we love that, can we please do that? Well, no, we can't. Then we get everybody's hopes up. So that's the direction I would say, is we need to get it set up in that fashion. We
And I
have
would-
we have a
yes.
pretty good process model we've used.
And I would suggest a series of workshops
Yeah.
with the council, with the developer, that are open to the public, where we can have PowerPoint presentations, we can talk about options. Here's one option, here's another option, get feedback from the council and for the public before anything's put in stone. Because, as Clay said, we don't want them to go down a path that later, when they're in the development process, you can't do that, that's not allowed by the code, you have to do it this way. You know, or if they propose some sort of agreement that we cannot be party to, they need to know that ahead of time, so that by the time we're ready to take ownership of the property, everyone understands what that means and what's going to happen.
Mr.
But
Mayor.
absolutely.
Councilwoman Brandy?
Oops, sorry.
Thank you, Mayor. I don't have a problem with doing any of this, but I want us to be real cautious on the council about meeting with developers, especially when it's something as large as what's coming in there. And I don't really, and then there's no offense here, Councilman Dickey, but I don't see the need for a council representative to have on those meetings when we've got a city manager that we pay for that. I think that kind of crosses the line almost, and it almost gives a false sense that the council's behind this meeting when it's gonna take 3 votes no matter what we get up here to really make it, you know, to get it through. So that's kind of where I'm at with it. I didn't know any developers were meeting with anybody or any of this other stuff either. So I just want us to be real cautious, and I also want us to take the things that we've learned with the Hammock Bay Sports Complex, as much as that may be the apple of our eye in this community, there's a lot of things that happen with that hopefully we've learned from.
Yes.
On this next sports complex endeavor that we're going to do. No matter how we do it, we need to make sure it's done correct.
Absolutely.
And that's all I've got to say.
And the
Councilman Ferris?
And the thing is, if Tracy wants to step down, we'll have Mark there,
Yeah.
however you
I
wanna
just
do
want us
it.
to be
I don't
real
I
know.
want to say,
cautious.
y'all voted on me meeting
Yeah,
with the
Yeah.
developer.
and we did.
In front
You
of this
did.
council, so
Yeah.
that was
And I'm gonna
the
say
only meeting
that when me and
Yeah.
Charlie, when I was talking to Charlie, there wasn't a whole lot of I was just talking about the sports complex, because my thing is wanting to be able to see this thing develop, and I know it's gonna take years. And that's when Charlie was telling me about the schools and everything. And it's something, at least this gets it started.
I mean, all we've
And-
seen is that one conceptual
Yeah,
plan, so
and-
all of this change.
And hereby
That's what
getting
gives me the red
started,
flag.
then it comes back.
Yeah.
But at least it gets this discussion started with them. And we can end up with Mark, you, Red,
Right.
and then go from there.
Well, the
'Cause it's gonna-
current conceptual plan that all of you have held and looked at is still in place.
Yes.
The current resolution is still in place. And I think it's a very good idea to have several workshops to talk about these public facilities that are being offered before anything is considered in terms of changes or revisions or additions to that. I think that your feedback would be invaluable before that happens. Because ultimately, if the property belongs to us, we need to feel that we're doing what's best for the citizens, that we're meeting the needs that are out there in terms of our children, and that we're providing what we know to be the right mix of uses for this park that's going to serve our community. And we have learned many lessons over the years with the sports complex, what works, what doesn't. It's been a learning experience for everyone. So we will take that knowledge absolutely into consideration as we move forward with plans for this park.
One other just comment from me, which is everything that was said, is why I asked the question that I asked. Because forget about it being the car property, especially those of you like Ms. Brennan who have been up here a million years. The worst thing in the world, in the development world, is for a council to approve a conceptual and then the pieces parts come back for approval in a different format. And so it's very important for me for the developer to know and for this council to know, they gotta come through here. And I think workshops and doing it right here is the way to do it.
That's what I
Yeah.
think too.
I agree.
Total transparency, yes.
Yeah, total transparency.
And we'll encourage Walton County Public Works and Walton County Parks and the school district facilities planning to be here so that they can talk about their needs and what's important to them, especially the school in terms of its security requirements. I mean, we all are acutely aware that schools have to be more careful than ever. We understand. But we want to make sure that we do something that's usable and practical, but is going to address a multitude of needs. That's the most important thing, I believe. So we will move with caution. We'll have those discussions, and then we'll work on a series of workshops where we can invite our sister agencies to be here, and then we talk in an open forum about what's needed, what's working, what's not working, so that everyone feels that they know how the city's moving forward.
Well, and we also need to remember budget's about to come up and we're gonna already be in a ton of workshops. So I don't know if we should like hold this to the fall or try to mix it before budget, but I'm thinking we're about to have a ton of other meetings. So is the county, so I don't know if this really needs to be rushed now or you wanna do the workshops later. I'm just trying to think about our schedule. It's gonna
I
be a lot of
will
meetings.
do some quick conversations with all the parties involved, because as you know, Walton County's starting its budget workshops. And I don't know if it's going to need, I don't even know if they would be able, well, so's the school district for that matter. I mean,
Right.
we're all dealing with, statutory budgetary things.
Right.
I will take a quick poll of everybody involved and probably send you all just a little notice based on this. We'll probably do this during this time frame and just give you a little up-to-date
Right.
on
And you can
where
just
we
wait a
are on
few
that,
months and
or I
then
may
try to
end
do
up
it
being
then.
able to just give you an update at the next council meeting that I've discussed it with everyone, and we think workshops can occur in this time frame. And,
And it's something that doing it in the fall,
Yeah.
there's no
Yeah, I mean,
problem
it
with
could
that.
just be after we kind of get done with, maybe
Sure.
August, September,
Yeah.
when you get done with all the stuff in the summer. I'm just thinking about that, but.
I'll work on that. I'll try to have you some concrete answers back on schedule by the next meeting.
Thank you.
Thank you.
To approve.
So what do we have? Sorry.
Is a motion second to create a group of people to meet with everybody? I think the question from Councilman Brown was the inclusion of the council member on that list.
And that was, and I said that's fine, as long as we understand.
So assuming that's still everybody's intention, we've not changed it, we're ready to vote on selecting that group to meet with the county, school district and developer to advance this project.
Did you second it? We don't have a second.
I just have one comment, and this,
Oh, there wasn't a second.
Oh, I thought
Like,
that was second.
a question, okay,
I did too.
can I go ahead and amend that, of taking Tracy off and leave it? How do we
Well,
need?
you don't have a second, so at this point, yes, so let's
Okay.
go ahead and let him amend the motion and see if
All right.
somebody's willing
All
to
right,
second.
Well, I'm gonna make the motion to approve to have our city manager, our city planner, and parks director to meet with the other school board, county, whatever, being able to come up with everything that we've discussed and come back to us. For how do I need to phrase that?
I think that gives us general direction based on the discussion.
All
That's
right.
sufficient if that motion is in effect.
Is there a second?
Second.
Second, any further discussion? Is there any public comment? Councilwoman Hafner?
Aye.
Councilwoman Hurst?
Aye.
Councilman Ferris?
Aye.
Councilwoman Brandon? And Councilman Dick.
Aye.
Motion carried. Next is public comment. Rachel White?
Morning,
Hi,
Good
how are
morning.
you?
Mayor, Council. I have I've never done this before, so after watching them present stuff, I just have a speech that I have wrote out for you guys, basically talking about your water policies, and letting non-traditional deed and tenant owners be allowed to have water. I'm just going to read this and you'll know what I'm talking about. I am here because my children and I have been without running water since April 7th. I want to be clear what I'm asking the council to consider. I am not asking the city of Freeport to decide my divorce case or any litigation issues, or decide ownership of the property. I am asking the city to address a policy gap that can leave lawful occupants, including families with children, without access to an essential utility. I am asking, right now I have been told that water service can only be placed in someone's name if that person is on a deed or has a tenant or lease agreement. That might work for normal landlord situations, but it does not work for every family situation. It does not work when a spouse or parent is living in a home with minor children. It does not work when one party can use control over utilities as pressure, punishment, or leverage. It especially does not work when the children are the ones forced with the consequences. When I asked the water department how this issue can be addressed, I was told that this policy was set by city council. Sorry. I was also told my documentation would be forwarded to the city attorney on April 13th. I have not received a written response. That is why I'm here today. I have tried to follow the proper channels. I have provided documentation showing I am legally allowed to be in this home. I have attempted to work through the court system. I have sought help. But while everyone decides which box I fit into, my children and I do not have running water. A water account should not become a weapon in a domestic or family dispute. A city policy should not give one person the power to cut off basic living conditions for a household with children simply because the other parent or spouse is not on the deed. I am not asking the city to abandon its safeguards. I am asking the city to create an emergency alternative to the renter affidavit for lawful occupants who do not fit into the traditional lease category. The point is simple. There needs to be a safe emergency pathway so that water is not interrupted while paperwork or court issues are being sorted out. Because this item is listed as a request for an emergency utility access policy, and because the agenda states the city may take action during this meeting, I am respectfully asking this council to not simply see this as a public comment and move on. I am asking the council to direct staff and city attorney to immediately review and create an emergency pathway so lawful occupants, especially families with children, are not left without running water. This would not, again, decide ownership, create a lease, or determine marital rights. It would simply keep children and other occupants from being left without running water while legal issues are being resolved. This is not just about me. I was told at the city water department that this is a common occurrence. If this is true, this is not a one-family problem, it is a policy problem. Freeport has the opportunity to fix this gap before another mother, father, or child is caught in the same situation. Thank you.
Council want me to address? So, staff did reach out to me. I spoke with Mr. Martin and Ms. Hewlin at length about this. Appears they're have been 3 different judicial proceedings that Ms. Likes is involved in. One, a case for ejectment from that property filed by an individual by the name of Geiger, last name Geiger. Then, of course, there are the family law proceedings. This point in time, we've not been presented with any court order, despite the fact several have been presented, attempting to address this issue. It appears at least one effort by Ms. Likes to obtain emergency relief to stop the utilities from being cut off was denied by the court. Now, the issue we have is very simple. If we allow someone to establish a utility account for property that they do not own or have a leasehold interest in, that is an unbridled scenario. What she's asking, and I understand the point that she's making, but unfortunately she's asking this city to take a position that someone with no identified legal interest in property is able to create a utility account and oust the person with legal authority over that property from being in utility service. We would effectively be creating tenant holdover scenarios. And yes, I am aware that staff did make the statement, this happens. But I want to be very clear. There's something that I don't know that staff said to Ms. Likes or not. There's a Florida statute, 83.67, that makes it absolutely, strictly prohibited for any landlord to disconnect or interrupt essential utilities, which are defined as electricity, water, heat, and gas, of a tenant. Even if the tenant is behind on rent, or if the lease has expired or is no longer operable. Now, in every bit of the pleadings I've reviewed in this case, and I cannot offer Ms. Likes legal advice, and I will not be offering Ms. Likes legal advice, but what I will absolutely tell you is that this is an ongoing dispute about the occupancy of that home. 8367 certainly is what we rely on to keep people from doing this and cutting this off, but more importantly, it is a defense and a right of someone to use in a legal proceeding. If we get a judicial order, water's going to get cut back on. But otherwise, the logical end of this is that someone goes into a house that's not occupied year-round, moves in, and comes and cuts on the water. The owner calls and says, hey, there's a squatter living in my house. How'd y'all give them water? Well, we have this policy that says if somebody comes in and asserts there's a dispute over right to be there, we've just got to give them water. Otherwise, or we're going to be adjudicating every single dispute. And what I can tell you is this is a civil dispute quintessentially. And it is incredibly difficult to adjudicate those. I feel for every judge that has to adjudicate those issues. I think everyone up here knows I practice this type of law. These are incredibly difficult cases. But I can tell you, in 2 decades of doing that, I've never once had any local government anywhere in this state take action when there is not a court order in effect. And there's not a deed with the name on it. And that's the rub we've got right here. So, I mean, I don't believe this is a loophole in our system. I believe it is a very consistent policy that is very difficult for us to change. But if the court is able to give you relief and is able to grant relief under 8367 or otherwise, and there's an order granted that says that those are to be restored or to cut back on, send it to us and we will absolutely take care of it. But we have to get a court order. That's where we're at.
I did give you a court order. My ejectment is an ejectment of a stay. This is my children's father. I am not just some squatter in this home.
Yes, ma'am. I reviewed that order.
I have been here for 3 years. And that ejectment right there states I can stay in that home until further pending family issues are resolved.
That is correct, but it says nothing about utilities one way or the other. In fact, the order on the defendant's motion to clarify and enforce case management reads, the judicial economy and the need for consistency of rulings dictate the court should stay the proceedings of this matter pending resolution of related proceedings in 25 DR 16 and or 25 DR 663. So that is the extent of that order on clarification.
There was an initial motion. After a motion for stay, the court entered that clarification. When I read that order on its face, it merely says you've got to defer to the family law courts. If you have an order from either one of the 25 DR cases that specifically grants some form of relief as to utilities, then please provide it to us. But I can tell you that in January of this year, the court did ultimately deny one of the motions for temporary relief.
Ex parte, yes.
And so, and then there's been, on February 7th, there was another order for emergency relief, was there not?
There were a couple orders, actually, and a recent one, and they were all denied because of ex parte. He wanted to have a hearing.
And that's the problem, is that on April 7th, a few days prior to her coming in, the court issued an order on her emergency motion for temporary relief to maintain the status quo, which would be the utilities and other relief, that denied it. And at this point in time, I'm not willing to tell the city that we go against our policy in light of a court order. And I'm not speaking to the merits of your case. You may have a great case and the judge may have been wrong on every one of those rulings. It may be technicalities that made him right. But we can't adjudicate that, is what I'm telling this council, or we're going to have to change the policy for everybody. And I know that is a very harsh outcome, Ms. Likes, and I know that is a very harsh remedy. Council tells me they want to go otherwise, we'll rewrite the policy if you want to take what she says, but I have to give you my advice because you are my client.
Would you consider doing another affidavit that doesn't say renter? Because the only reason why my ex-husband will not sign that affidavit is because it says renter at the top.
I don't see how the city, unfortunately, can look at who has rights to be on property unless we're going to start recognizing squatters' rights.
Well, I mean, squatter is different from someone who has received mail at that home for several years. That's totally different. I didn't just show up to a squatter is someone who either doesn't get out after a lease agreement or shows up, like he said, to the house and they're not supposed to be there. That's the safeguards I'm not asking you to change. I'm asking maybe, I'm sorry?
You rent the home?
My ex-husband owns the home. It's solely in his name. Yes.
Did you live there prior to the?
I've been with him 12 and a half years, yes.
The problem here is that this is not a situation where the court has not spoken. And I want to digress for a second. And as a mother, I'm very sympathetic to you. And I think this is a terrible, situation. And I think that we all feel for you, the situation that you're in. So, but there are two different avenues that we have to look at here. Even though I feel that our hearts go out to you for what you're experiencing, legally, we have to abide by the law here. And not only do we have a situation where you've got legal proceedings going on, and these things are involved, the judge in that proceeding has actually spoken to these issues. So this isn't just, we don't have guidance because it hasn't been brought up. And we don't know the parameters of what exactly has been discussed, and in the pleadings, that's out there, and that's not for us to decide and to look at. That's a civil matter, and as Clay said, that's something that needs to stay within your lawsuit and your proceedings. But you have to understand, we have to, that's not our role here, unfortunately. And we can't make policies for specific people in specific circumstances.
Right.
So to do this would open up the floodgates that Clay's, referring to, that would allow people that have no genuine right to be on premises to turn on utilities. And then the legal ramifications that we would be in if we allowed that. So unfortunately, that's where we're at. So as Clay suggested, and none of us are here to give you legal advice, myself either, but these things need to be brought back to your proceeding, your judge, and you need to have those conversations with your attorney representing you there. And if you get a court order that says differently, you need to bring it back to us and we will re-entertain this. But at this point, our hands are tied and we're just not in a position, unfortunately, that we just cannot do that.
I'm not too sure of the policies since I don't live in California. But I do know that California, New Jersey, and I'm from Indiana, so Indiana as well. They have policies that the water cannot be shut off unless if someone either buys the home, takes over, or if someone's living there to prevent this situation right here, to prevent this, whether, again, domestic violence or family disputes, because genuinely, it is used as a weapon. And I was told that to my face. So I'm not asking to change it just because of me, but because this is a common occurrence, and you guys all state that children, 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 and it's not even just about children. It's about either an ex-husband or an ex-wife who might still be in the same home. And I get that it's court proceedings, and I get that my judge said no due to ex parte, but there's gotta be something that protects people in this position, as there is in
And
other
that's what
states.
He was bringing up the statute that does protect in this circumstance.
Not when it's
and-
a tenant.
Well, but there is a process and an avenue for that to occur, and without getting into the merits of your case, we
Right.
cannot, we don't know all the parameters of that.
No.
And I will add that I did review, and I'm very familiar with Standing Administrative Order 2020-31 in the First Judicial Circuit, which is commonly referred to among family law practitioners as the status quo order. That is required once a dissolution of marriage is filed in the state of Florida to be served on all parties. It deals with a variety of issues. I will be very candid. That document has been in effect for now about 6 years. It's gone through a few revisions over the past several years, but prior to that. It does not specifically speak to maintaining utilities or things like that, but it has some very broad language in there that's often used in temporary relief hearings to obtain this kind of relief. I did look to make sure that it was the standing order and there was not any kind of modification to it. While it does apply, it does not specifically speak to that. It specifically, though, does include language that the provisions of it are not to be interpreted to control property which is co-owned by a third party or to dictate or mandate what property rights may be affected to any third party. That's the city in this case. It does say, in such a case, either party may file an appropriate motion with the court with notice to all whose property rights may be affected so the court can adjudicate this. I will tell you, I know staff says they have this come up all the time. I don't see Morgan, so I'm not going to put her on the spot, but I can tell you that, again, and having represented the city now for over 20 years, I can't recall a situation that's exactly like this. We have had numerous renter scenarios. That is very common. We have also had people who have been occupying a home without a tenant agreement and just stayed there, and now the person wanted out. That was the most recent one we had. So I think that's probably more of what she's referring to. But I will say we have had notices served to the city, both here and in the Puniac and in Paxton, under that pretrial order trying to adjudicate that issue. Our response is to merely notify the court that we will do whatever the court requires. Here's the information, and let the court make that happen. And so what I would say is that as soon as we get something from a court, we will gladly do what we can, Ms. Langs.
Thank you. Thank you.
Thank you.
Is there any further comments, public comment? If not, meeting is adjourned.